Kevin with Crayon Law Firm. I also have my colleague here,
Attorney Mark Elliott.
the two of the foremost experts in the field.
What we're here to talk to you about today is what we see most commonly in terms of a basis for bringing a lawsuit against either a current employer or a former employer. There are a handful of federal statutes that apply and give you a protected stature. However, the one we encounter most often is Title VII.
Title VII, or any kind of discrimination-related laws and statutes, federal law will protect you nationwide.
A lot of states have a very narrow scope of actions that can be brought under state law. And this opens the door for the utilization of federal law. Again, the most common, but not the only, being Title VII.
Title VII and other discrimination-related laws, they contain many protected bases. For instance, the basis of sex or gender, the basis of race, religion. These are all protected under Title VII, including retaliation for engaging in Title VII activity.
What we need to show is not just that you are protected under Title VII, but that you were terminated for that reason. Now, in the multiple years that both of us have been in this body of law, I'm hard-pressed to think of any situation where I've encountered an employer so stupid as to say, I'm firing you because you're Chinese, or I'm firing you because you're Jewish, or I'm firing you because you're Catholic.
And what my colleague, Attorney Elliott, is referring to is what's called direct evidence of discrimination. Some cases do have them, but it's very rare, right? It's very rare to have an employer say, I terminated you because of your race or your gender or because of your disability. So that's what you call direct evidence. The large majority of cases do not have direct evidence, so you have to prove discrimination in other ways.
And the common way that this is done is through a concept called disparate treatment,
otherwise known as favorable treatment or preferential treatment. One person is punished for the same infraction while another person that's outside of that person's race class, sex class, disability class is not punished.
That leads to a disparate treatment claim.
One thing that is very important in a disparate treatment claim is that you must be similarly situated to the person you're comparing yourself with. For instance, if you are working for the Postal Service and you are a letter carrier, the person that you are comparing yourself with has to also be a letter carrier. There's very little flexibility in this regard. You have to be similarly situated as your comparators.
To Attorney Crayon's point, yes, you must be similarly situated. Where that occurs and where treatment has been different, there is a viable claim that can be made under Title VII.
And so what that does is that establishes what's called the prima facie case. That's just the Latin legal term for the essential elements of your case. You cannot have a sandwich without bread and without the fillings that go in the sandwich. Okay? So without these elements, the case fails. And so to prove discrimination, if you do not have direct evidence, like Mark and I described, then you have to compare yourself to somebody else. Now, discipline is one way that you can show that, but it can also be other adverse actions other than discipline. Or it could just be any kind of action that affects your grade, your pay, or the terms and conditions of your employment. It is about disparate treatment.
So we've said a lot here today to make you aware of these concepts. What's generally best is a one-on-one conversation where you call one of us and we engage in dialogue about your specific circumstances as opposed to just a general awareness that these things exist.
It is not one size fits all. You need to have your individual case looked at. We specialize in this area. Give any one of us a call. We'll be happy to give you a free consultation.